Start. Aggrieved by the impugned judgment of the Allahabad High Court, the appellant has approached this court with a simple question of law, as to whether the High Court erred in modifying the arbitral award to the extent of reducing the interest, from compound interest of 18% to 9% simple interest per annum stop, partly allowing the appeal, the High Court disapproved the reasoning in the award on claim number 6. It held that the sum of rupees 3 lakhs awarded towards compensation for loss caused due to non-issue of tender document and paralyzing business could not have been granted. The High Court held that it could not be said that the proceedings (start) in the present case were under the Arbitration Act, 1940, and therefore, the rate of interest granted should not be 18%. Stop para. The ground praised by the appellant in the present proceedings, relates to the modification of the rate of interest (start) relating to award in claim number 9 and the scope of this appeal is limited to this question para. Miss Neeraj Singh, counsel appearing on behalf of the appellant, submitted that their claim was in fact for 24 pendente light interest, and the arbitrator had already reduced it to the 18% granted stop, pointing to pre-amended section 31 7 B of the 1996 Act, it was contended that the High Court erred in reducing the statutory interest rate, this provision prescribed that in the event the arbitrator did not give any specific directions as regards rate of interest on amount awarded, such amount shall carry interest of 18% per annum stop. The arbitrator had properly considered the matter and accordingly granted 18% past pendente light and future compound interest on 8 claims, which was affirmed by the district court stop. Counsel also pointed out clause 70 of the general conditions of contract (GCC), which stipulates that the award of the arbitrator shall be final and binding on both parties stop. It was urged, therefore, that there was no justification for judicial interference so as to reduce the statutory interest rate from 18% to 9% per annum. Counsel drew attention to Sahi versus State of UP and others, wherein this court, in light of section 31 7, upheld 80% per annum as rate of interest, as justifiable stop, to argue that when the agreement between the parties does not prohibit grant of interest and where the party claims interest in the dispute referred to an arbitrator, then the arbitrator does have the power to award interest pendente light stop.